everyone, my name is Maryam Mekhail and I'm a wills and estate planning lawyer at Madison law firm. In this video we'll be talking about what you need to think about once you've already made and executed your will. The first thing you need to think about is safe custody of your will or your other important testamentary documents. Safe custody of a will is fundamental. The executed will should be kept in a safe place, such as in a secure, fire and waterproof document safe. You may choose to seek out a safe custody service, such as with lawyers like our firm, or you can choose to leave it with the Supreme Court itself. Now, you should ensure that your executors know the location of the will and have access to it in due time. It may be useful to maintain a bank safe custody box, but if you do this, you should ensure that it won't create further barriers for the executor when it comes time to actually retrieve the will. If you choose to keep the will in your home, you should be aware of the potential risks that are involved. This includes the risk of it being accidentally lost or destroyed. It can be stolen or deliberately destroyed or read by others, and of course that's not something that we want. So if you've made your will, make sure it's kept somewhere safe, secure and accessible. The next thing you want to ask yourself is, when should I review my will? We usually recommend every 3 years or whenever your financial or personal circumstances have changed. Some examples of events that may trigger your need to review or update your will are if you want to change a beneficiary, for example, or an existing beneficiary has passed away. You may want to change the executor that you've listed or the person that you've appointed as the ideal guardian of your minor children. Other examples are if you have any major changes to your assets, if you've acquired or disposed of any major assets. This is particularly something to consider if you've disposed of any assets that you specifically gifted to someone in your will. Similarly, if your personal circumstances have changed, you may need to update your will, such as if you marry or remarry, you separate, divorce, enter into a new relationship, or you have a further child. One thing that a lot of people don't realise is that if you've made a will and then you marry someone, your will may become invalid. Or if you've made a will during your marriage and then divorce, then parts of your will may become invalid insofar as they relate to your former spouse. These are certainly things that you should discuss more specifically with a qualified lawyer. Which brings us to the actual changing of the testamentary wishes. You can do this in a few ways. If you want to make a minor change to your will, you can do this by adding a codicil or addition to the existing will. You can also change your wishes by completely revoking the existing will and writing a new one. The new will must then state that you revoke all previous wills. Alternatively, you can destroy the will lawfully. Now, no estate plan is complete without considering some of the other relevant and important documents, which is why we usually recommend creating a holistic estate plan. With the help of an estate planner, you may want to think to yourself, do I need a power of attorney? Do I want to appoint someone to make decisions about my medical treatment if I can't do so? You may want to choose to prepare an advanced care directive to act as a guide for your medical treatment decision maker. Or you can write a statement of wishes to accompany your will. You may also need to note on a separate document why certain decisions were made in the way that they were when making your will. Now, these are all important aspects that you should consider when addressing your future planning to ultimately protect your assets and give effect to your intentions. So in summary, the key points that you need to remember or consider after you've made your will are the safe custody of your will, making sure that that's a fundamental consideration, that you should revisit or update your will every 3 years or when your personal or financial circumstances change, that there are a number of different ways that you can change or update your will, and it's best to probably contact a lawyer for guidance with this, and that it's always best to address your estate plan holistically to make sure that you've considered all of the aspects of your future planning. I really hope this video has provided clarity and understanding for many of you, and if you have any questions or need help with your own estate plan, feel free to contact me directly through the details provided with this video. Thank you and have a lovely day.